5 seconds to go. Start. Contract appointment to the post of professor was offered to respondent number 1 on 1st May 2007 on the terms and conditions set out in the written offer. Respondent number 1 joined on 3rd May 2007. Clause 5 of the offer of contract appointment dated 1st May 2007 clearly recorded that respondent number 1 will be entitled to benefit of CPF. It is not the case of respondent number 1 that any grievance was made by him before accepting the appointment about clause number 5, which limits his entitlement only to the CPF. The appointment of respondent number 1 was regularized on the basis of the regularization rules. Rule 4 of the regularization rules provides for the regularization of the appointment of the academic staff appointed on a contract basis. It provided that academic staff appointed on a contract basis in terms of bylaw 22A of the said bylaws shall be deemed to have been appointed on regular basis against their respective sanctioned posts, subject to being found fit by the selection committee after evaluating their performance. Rule 6 of the regularization rules has been interpreted by the High Court and the Tribunal. Rule 6 reads thus: in the event of deemed appointment of the services of the academic staff appointed on contract basis, no pensionary benefits would be given other than as available under the new pension scheme of the Government of India is made applicable with effect from 1st January 2004. This will not affect employee who was initially appointed on a regular post and presently holding his/her high academic post on contract basis and already subscribing to either CPF or GPF cum pension scheme of the institute from the date of their initial regular appointment. Their existing status will remain unchanged. No arrears of pensionary and related allowances for the past service will be paid in case of deemed appointment. However, past service rendered by these academic staff appointed on contract basis may be taken into consideration for their future promotions, if any, as per norms eligibility prescribed by the institute for other academic staff appointed on regular basis for this purpose, as made applicable from time to time with the approval of competent authority. The deemed appointment will have no impact on existing basic pay and allowance presently being drawn by these academic staff appointed on contract basis, and they will continue to draw their existing pay and allowances as per norms. We may note here that the employment of respondent number 1 was regularized by the office order dated 4th May 2012, which specifically records that the order will take effect from the date of issue of the order. The said condition has not been challenged by respondent number 1. Therefore, he cannot claim that his employment has been regularized with retrospective effect from the year 2002, when he was appointed on a contract basis as an associate professor. The exception carved out in Rule 6 provides that the main part of Rule 6 will not affect an employee initially appointed on a regular post who was presently holding a high academic post on a contract basis and who was subscribing to either CPF or GPF cum pension scheme of the appellant from the date of his initial regular appointment. This exception is applicable to a member of the academic staff who was regularly employed not on a contract basis earlier, but was holding a high academic post on a contract basis when the regularization rules came into force. The exception will not apply to an employee like respondent number 1 whose first appointment was also on a contract basis, and the appointment to a higher academic post was also on a contract basis. Stop.